In this video, the subject that will be presented is Fundamentals of Criminal Investigation. Fundamentals of Criminal Investigation with Intelligence is a subject which is provided under CHED Memo number 5 series of 2018 in accordance with the provision of Republic Act number 7722 or the Higher Education Act of 1994. Okay, from the title itself, we can say that it is the most important subject in this division, considering that it is the basic of investigation. Therefore, the topics that you will learn here will serve as your foundation in other advanced investigation subjects such as traffic management and accident investigation, fire technology and arson investigation. We have also drug education and vice control, organized crime investigation, and special crime investigation. Okay? Usually, some of the students says that this subject is one of the most difficult subject. Okay? However, it depends upon your motivation. Okay? So, according to Henry Ford, sabi nga niya, whether you think you can or you think you can't, you are right. Okay? So, sabi po ni Henry Ford, the one who introduced the mass production of motor vehicles, no? So kapag ka iniisip mo na kayang-kaya mo ang isang bagay, totoo, mangyayari po 'yon. Okay? O kaya kung iniisip mo na hindi mo kaya, syempre marami pong dahilan. Pero kung iisipin mo na kaya mo, talagang makakaya mo kahit gaano kahirap 'yan, no? So it is just a matter of mindset, ladies and gentlemen. Okay? Ayan. So dapat i-mindset nyo. Okay? Sabihin nyo sa sarili nyo na kayang-kaya nyo. Madali lang. Tama? Okay, so please grab a pen and paper and take down notes for the things that you will learn from this discussion. Okay? So let us start. Okay, let us answer the preliminary question. No? Based on etymology of terms, investigation was fundamentally derived from blank, which means to search or to discover in English. Okay? Letter A, Latin word vestigare. Letter B, Latin word investigat. Letter C, Latin word vestigum. Or delta, French word vestigare. Okay, saan nga ba na-derive yung pong word na investigation? Ang ibig sabihin is to search or to discover. Diba? To search something or to discover something or somebody. So that is the Latin word investigat, ladies and gentlemen. Okay? So some sources states that the word investigation was also derived from the word or Latin word vestigare or investigare, which means to track or to look into traces. Okay? So it means that you need to look the traces or tracks in order to discover something. Diba? Samantalang yung Latin word investigat, which means to search, no? Or to discover something. Okay? Then these two may have been fundamentally derived from the Latin word vestigum, which means footprints. Okay? Because before, via their footprints, then you can trace or track a certain person kung saan siya papunta. Diba? So yun po. Kasi kung ikaw ay dumaan sa isang lugar, then you will of course leave traces or tracks. Okay? Wherein by those tracks, you can be discovered. Okay? Wherever you will go. Ayan. Lalo na sa putik. Di ba? Ayan. So, in short, in etymology of the word investigation, it came from the Latin word vestigum. Then after which, the Latin word vestigum naging investigat or investigare. Pagka investigat, anong ibig sabihin nun? To search or to discover. Or kung vestigare or investigare, ang ibig sabihin nun, or to track or to look into traces, ladies and gentlemen. Now, what is investigation in the modern definition? What is investigation? Okay? The word investigation is very generic, ladies and gentlemen. Okay? Yan. Kasi kapag meron kang dinidiscover na isang bagay, okay, in order to establish the truth, that is already investigation. Pero kapag ang ini-establish mo is regarding a crime, it is called as criminal investigation. So what is investigation? It has a lot of definition. Or judicial or otherwise, maaaring hindi judicial, for the discovery and collection of facts. Okay? So ano nga ba ang facts? Something that can be shown to be true concerning matters involved. Yan. So it is an inquiry or investigation procedure, either judicial or not, for the discovery and the collection of facts concerning matters involved. Another definition, investigation is to carry out a detailed examination or inquiry, okay, usually in an official manner to discover something or somebody. Okay, when we say in an official manner, it should be conducted in a systematic or a scientific manner. When we say systematic or scientific, no, it has to undergo the process. Okay? So, step-by-step procedure, meaning to say. Yan. So, another definition of investigation, it is the process of inquiring, eliciting, soliciting, and getting vital information or facts, circumstances in order to establish the truth. Okay? So kung ang tanong, what is the purpose of investigation? To gather information or facts in order to establish the truth. Okay? So kailangan mo na hanapin po yung mga totoong pangyayari, okay? Yung mga impormasyon tungkol sa totoong pangyayari para po ma-establish mo ang katotohanan at pawang katotohanan lamang. If your inquiry is regarding the establishment of facts regarding a crime, then ang tawag na doon is criminal investigation. Okay? Another definition, the act or process of investigation or the condition of being investigated. It also refers to a search or inquiry for ascertaining facts, detailed or careful examination. So kung makikita natin na maraming definition, but it has the main core, okay? The main core of investigation is to get facts in order to establish the truth. Ladies and gentlemen, take note, if you are trying to investigate a crime in order to establish the facts regarding that crime, okay, then ang tawag na po doon is called criminal investigation. Okay? However, if you are just trying to inquire on something to discover the truth, it is called investigation. Ayan po yung difference. Okay? Ayan. What are examples of things to be investigated? Ano nga ba yung mga iniimbestigahan? Okay? So, anything which facts should be ascertained and truth should be established. So, kahit anumang pangyayari, anumang bagay, no? Basta meron kang hinahanap, no? Na katotohanan or kailangan mong hanapin po yung mga impormasyon para po ma-establish mo ang katotohanan at pawang katotohanan lamang. Okay? But, sabi niya, in law enforcement point of view, especially criminal investigators, things that needs investigation are crimes. And some of the most common crimes are crimes against person. Ano nga ba yung mga crimes against person? You have murder, you have infanticide, homicide, yan, and other physical injuries. You have crimes against property such as theft, robbery, carnapping, and the like. And you have also crimes against chastity. No? Like for example po ay acts of lasciviousness. Ayan, so yung crimes against woman po yan, usually yung crimes against chastity. And uh, other acts which are prohibited under the law. Okay, so let us discuss, ladies and gentlemen, later on the different types of crimes. Yeah. So those are the examples of things to be investigated. So what is crime? Okay, in its legal definition, crime is an act committed or omitted in violation of public laws forbidding or commanding it. So there are two ways on how to incur a crime. Okay, either you have committed an act which is forbidden by public law. Okay, sa Tagalog, ginawa mo yung pong isang ipinagbabawal, crime po yun. Yan. So, bawal pumatay, sabi doon, no? So, kapag ka ginawa mo yon, then definitely may crime kang nakumit. Okay? So, or you have omitted an act which is commanded by law. Pinag-uutos ng batas, then hindi mo po ginawa, then yun po ay crime. Ito pong kinumit mo yung isang act, okay, na ipinagbabawal ng batas, ang tawag po natin dyan ay intentional felonies or intentional crime. Yun namang inumit mo or hindi mo nagawa yung ipinag-uutos ng batas, ang tawag po dyan ay culpable crime, ladies and gentlemen. For example, hindi mo na-check yung preno ng sasakyan mo bago ka bumiyahe. Then na-aksidente ngayon, meron ka bang pananagutan? Yes. Okay, because you were not able to make the act which is commanded by law bago ka nagbiyahe, na kailangan i-check mo muna yung sasakyan. Okay? In its social definition, crime refers to an act which does not conform to the norms and standards of the society. Ayan. So kapag ka sa ating society or ang ating society ang nag-define, lahat ng mga gawain na hindi po tugma doon po sa nakaugalian ay considered as a crime sa ating mata. For example, yung pong isang lalaki na ginahasa yung kanyang kalabaw sa gitna ng kanyang farm or 10 hectares farm, then sa ating pananaw, yun po ay hindi po katanggap-tanggap. So we can consider that as a crime based on the societal definition or sociological definition of crime. But legally, he is not criminally liable. Kasi unang-una, private property kung saan niya ginawa, yung pong panggagahasa sa kalabaw niya rin yun, private property niya. Yan. Then definitely there is no crime that was committed. But in the eyes of the public, the act of that person does not conform with the standards of the society. Okay? So, ganun po yon mga kapangarap. So, ganun din po, yung pong premarital sex, yung nagsisex na hindi pa kayo kasal. Yan, di ba? It does not conform to the norms and standards of the society. So, based on the sociological definition of crime, that can be considered as a crime. Then, there are different types of crime based on law punishing such. Okay, crime which are in violation of the revised penal code of the Philippines or Act number 3815, which is the primary source of our criminal law. Pagka yun po ang na-violate, it is called felony. Okay? Then, offense ang tawag naman if an act or omission is punishable by existing special penal laws. It is the form of crime which is defined and punished by special penal law. Ano ba yung mga special penal law, ladies and gentlemen? Okay, you have presidential decrees, you have batas pambansa, okay, you have special orders, and the most common is yung pong Republic Act. Okay? Yung pong felony is punishable by Organic Act number 3815. Okay, so that is pagka yung 3815 ang na-violate, that is called felony. Okay? Ayan. Then another type of crime is called misdemeanor, okay, or infractions. Yan, misdemeanor or infraction, it refers to a light felony or light offense that is punishable by a small fine or short period of imprisonment in jail. An act or omission in violation of city or municipal ordinance or ordinances. So ang tawag po doon, misdemeanor or infractions of city or municipal ordinances, ladies and gentlemen. Okay? Ayan, I hope that the type of crime are clear to you based on law punishing such. You have felony, you have offense, and misdemeanor. Okay, next question. Illegal acts committed by business and professional people with high status while earning their living are classified as letter A, crime mala inse, B, blue-collar crimes, C, white-collar crimes, and delta, crime mala prohibita. Okay? So, what do you call the illegal acts which is committed by business and professional people? Yan. Oh, that is called as white-collar crimes. That is according to the definition of white-collar crime based on the definition of Edwin Sutherland, ladies and gentlemen. Okay? Yan. However, based on the definition of the Federal Bureau of Investigation, as long as the crime involves the use of fraud or deceit, panluloko at panlilinlang ang ginamit mo, then definitely that is considered as white-collar crime. Example po ng mga white-collar crimes are Ponzi, ayan, you have pyramid scam, you have investment scam, ayan, odometer fraud, and the like. Okay? In short, pag sinabing white-collar crime, ang ginamit mo ay galing at talino. Ayan, para ikaw ay magkapera. Ano naman po yung crime mala inse? Crime mala inse are those acts which are wrong from the very beginning, and usually these are punishable under our revised penal code. Yung pong crime mala inse. For example, bawal pong pumatay, di ba? Mali na po 'yon kahit sa Biblia, mali na po 'yon sa ating constitution and sa ating criminal law. Okay? So it is very wrong from the very beginning. It is wrong from the eyes of God, from the eyes of the people, and it is wrong legally. So these are crime mala inse. Okay? Then you have here blue-collar crimes. It is a crime wherein you have gained something through crime involving the use of violence. So ang ginamit mo naman, may nakuha ka na pera, okay, sa pamamagitan ng lakas ng katawan, hindi po talas ng isipan. Kabaliktaran po ito ng white-collar crime, ladies and gentlemen. Then we have here crime mala prohibita. These are acts which are wrong because they are merely prohibited by law. Okay? So meron bang mga mali dahil ito ipinagbabawal ng batas? Yes, marami po ang crime mala prohibita. For example po ay yung pong illegal possession of firearms and ammunition. Hindi naman simulat sa pool pa lang ay mali na po yun, no? Pero dahil may batas na nagbabawal po doon, kaya po nagiging mali. Kapag may hawak-hawak po yung civilian, wala pong lisensya na humawak ng baril, then there is a crime that was committed. Ganon din po ang illegal possession of dangerous drugs, ladies and gentlemen. Okay, so when we say crime mala prohibita, these acts are wrong because they are merely prohibited by law. At ang maganda pa dito sa crime mala prohibita ay mas madaling makonvict po yung pong mga offenders basta hindi po na-violate yung pong karapatan ng offender, then madali pong makonvict. Okay? Why? Kasi pagka crime mala inse, the intent should always be proven in court. Unlike sa crime mala prohibita, intent need not to be proven, no? Because the mere act is already the one which is punishable. So bakit ko po dinidiscuss yung iba't ibang klase ng crime, ladies and gentlemen? Because it is or these are the things to be investigated by law enforcement officers, especially yung mga criminal investigators. If there is no crime, okay, that was committed, then definitely the criminal investigation should not commence. Di ba? So, walang crime eh. Yan, di ba? Yan. So, nabanggit natin kanina, no, sa definition ng investigation, it is the discovery of facts in order to establish the truth. Ano nga ba ang facts naman? Okay, facts is something that can be shown to be true. Okay, to exist or to have happened. Yan, yung pong facts, yung pong maipapakita mo na totoo. O kaya ito po ay nangyari. At ano kaya ang pamamaraan para maipakita yung isang bagay na totoo sa pamamagitan po ng evidence. Di ba? So, it is an action or event or circumstance or something that has done. It can be explained further by distinguishing it from inference and opinion. So what is inference? Okay, inference is the process of reasoning by which fact may be deduced. Diyan po pwedeng manggaling po ang diyan po sa inference. Okay, when you say inference, ay pwede pong patunayan yung katotohanan sa pamamagitan ng inference dahil meron pong tinatawag na evidence. Okay? So, it is a conclusion drawn from evidence or reasoning. Okay? For example, bakit mo nasabi ang isang bagay? Dahil may nakita ka. Di ba? So, yun po, no? Nakita mo si Pedro, hawak-hawak po ang kutsilyo, tapos nakita mo na itinatusok na ito sa kanyang biktima. Okay? So, that is inference kasi may nakita ka. Pero kung salita ka ng salita, siguro namatay si Pedro dahil sinaksak. Yan po ay opinion lamang. Okay, ano ang opinion? Personal belief. Wala ka namang nakita pero salita ka ng salita. That is called opinion, ladies and gentlemen. Okay? Pero kung nagsalita ka dahil meron kang nakita, meron kang narinig, okay? You have just stated a certain thing because you have used you have perceived something using your five senses. It is called as inference. Okay, so what is evidence? Something that gives a sign or proof of the existence of or truth of something, or that helps somebody to come up to a particular conclusion. Okay? So, evidence gives a sign of proof. So, ano nga ba ang pamamaraan para mapatunayan na nag-exist yung isang pangyayari sa pamamagitan po ng evidence? Okay? It is the means sanctioned by the law in ascertaining a judicial proceeding respecting a matter of fact. Ayan. So, ito po yung pamamaraan na nakasaad po sa ating revised rules, no, of evidence ito po yung ginagamit na nakasaad sa revised rules on evidence sa pagpapatotoo, okay, sa isang pangyayari, okay, para mapatotohanan yung pong pinapatotohanan sa korte. Yun po ang evidence. Yan, so ebidensya. Okay? So ito po yung ginagamit para mapatunayan ang isang pangyayari. Di ba? So ito po yung sinasabi ni Gas Abelgas na gamit ang sensya, okay, lohika, ebidensya at pagkamaparaan ating aalamin kung ano nga ba ang nangyari. So, mula dyan, no, makikita natin na ang trabaho ng isang investigador ay humanap ng katotohanan at pawang katotohanan lamang at yun po ay kailangang patunayan sa korte sa pamamagitan ng pagkalap ng ebidensya. No? At parang madali lang, subalit ito po ay mahirap dahil may mga sinusunod na kung tawagin po ay procedural due process, no? Sa pagkalap ng ebidensya, sa pag-aresto sa accused and the like, no? Because the Constitution and the laws in the Philippines provide rights for the accused, okay? So, ating alamin kung ano nga ba yung pong constitutional at statutory rights ng isang akusado. Yan. So, what are the constitutional rights of the accused, ladies and gentlemen? Under 1935 Philippine Constitution, it is already present in Article 3, Section 17, Paragraph 1. It states that in all criminal proceeding, the accused shall enjoy the right to be heard by himself and the counsel. So, from that statement alone, in 1935 Philippine Constitution, the accused should be heard before it condemns, because here in our country, the accused is considered innocent unless proven wise guilty beyond reasonable doubt. Diba? So, considered po na inosente ang isang tao na nasampahan ng kaso unless kung na-prove na siya po ay nagkasala at hinatulan na ng korte, and that's the time that we can call him as a criminal. Okay? But then, pag hindi pa po ito convicted, he is called as accused. Pagkakahuli ng pulis, anong tawag sa kanya? Suspect or pinaghihinalaan pa lamang. Pagka po nakita ng prosecutor na meron pong probable cause to believe that the crime has been committed and the respondent is probably guilty thereof, then such person is called as respondent. If a criminal case was already filed in court, then that person is called as suspect. Then, if the court have already convicted him by final judgment, then that's the time that you can call him as a criminal. And of course, if that person have already served his or her sentence, he is called as ex-convict. So, doon pa lang sa 1935 Constitution natin, makikita natin na meron ng due process, no? May due process na. Nadidinggin muna ang panig po ng akusado at kanyang abogado para ipagtanggol siya sa korte, ayan, sa criminal proceeding. Okay? In 1973 Philippine Constitution, Article 3, ano ang nakasaad po doon? No person shall be compelled to be a witness against himself, that any person under investigation for the commission of an offense shall have the right to remain in silence, or that is what we call as right against self-incrimination, na kung saan hindi ka pwedeng maging testigo laban sa iyong sarili. Okay? To have a counsel and to be informed of such right. Okay? So may karapatan ka rin na kumuha at pumili ng iyong sariling abogado at yung karapatan ng isang akusado na ma-inform yung kanyang karapatan. Okay? No force, intimidation, walang pamamersa, pananakot, or any means, no, which will vitiate the free will shall be used against him. Any confession obtained in violation of this section shall be inadmissible as evidence. Okay? So, kung natakot yung tao, kaya nagsalita, nag-confess, then such confession will not also be admissible as evidence in court because that is violation of right of the accused against self-incrimination. What are the constitutional rights of the accused? So, this is a continuation. So, sa 1973 Constitution, meron na pong karapatan ng akusado na nakasaad po doon sa ating Constitution. Sa 1987 Philippine Constitution, Article 3, Section 12, Paragraph 1, ano nakasaad? The 1987 Philippine Constitution specified the constitutional rights of any person arrested or under investigation of a criminal offense. From the provision of Article 3, Section 12, these are the primary rights or constitutional rights of the person or of a person under custodial investigation or a person arrested. Number 1, the right to be informed of his right to remain in silent. Number 2, the right to have a competent and independent counsel, preferably of his own choice or to be provided with one. And number 3, the right to be informed of his or her rights. Okay? Yan. So, sana malinaw po yung kanyang tatlong karapatan, mga kapanga. Okay, next. What is Miranda Doctrine? Ano nga ba yung Miranda Doctrine? Di ba? Dahil ito po ay sinusunod ng ating Philippine jurisprudence. Okay? At ito rin po ay pinagkuhanan ng nakasaad po sa konstitusyon regarding the rights of person arrested, detained, and under custodial investigation. So, the Miranda Doctrine, it is a rule or principle in criminal jurisprudence that requires mandatory pre-interrogation warnings. So, it is conducted before interrogation start concerning self-incrimination and right to legal counsel of the suspect. The culmination of many Supreme Court decisions in United States focusing on the rights of suspect during police interrogation, as well as in the case of Ernesto Miranda versus State of Arizona in 1966. So ito po'y galing po sa kaso ni Ernesto Miranda versus State of Arizona. Okay, so it is an American jurisprudence. Okay, the Miranda Doctrine mandates that prior to any questioning, the police must let the suspect to know that he has the right to remain in silent, that anything he says can be or can and will be used against him in any court of laws. He has the right to hire and consult with an attorney and to have his counsel present during questioning, and if he cannot afford one, or if he cannot hire one or an attorney, one will be appointed to represent him before any questioning if he wishes one. And number 3, he cannot waive these Miranda rights except in writing and in the presence of the counsel. And take note, the Miranda rights should be stated in the language known to and can be understood by that person who will be put into custodial investigation or who will be arrested. So, kailangan po maipaliwanag doon po sa tao yung kanyang karapatan sa salita na kanyang naiintindihan. So, kung Tagalog, Tagalogin mo. Okay? So, kapag ka Koreano, humanap ka ng interpreter. Diba? Ayan po, mga kapangarap. Okay, ano pa? No evidence, either confession or admission, obtained as a result of interrogation can be used against the person questioned unless and until the Miranda warning were given and explained and waiver has been properly subscribed by suspect in the presence of the counsel. Pag sinabing confession, yan po ay pag-amin sa isang kasalanan or admission of guilt. Pagka naman admission, yan po ay pag-amin sa mga pangyayari lamang or admission of some facts. No? Ayan. So, how the Miranda rights are waived? The Miranda rights of the suspect are deemed waived after he subscribed a waiver. Take note, the waiver should be in writing, hindi po pwedeng oral. Dapat nakasulat at nakapirma siya, at nakapirma rin yung kanyang abogado, syempre. That his right have been fully explained to him, that he understood the nature of each right, and that he wishes to talk about the circumstances of the case being investigated. The waiver must be made accordingly and intelligently in the presence of a competent counsel. After giving the Miranda warnings, and in order to secure a waiver, the following question should be asked, and an affirmative reply should be secured to each question. And the question, or this question, should be present in the waiver. No? Ano yung mga tanong? Do you understand each of these rights? that I have explained to you. Then, after which, pag sinabing yes, having these rights in mind, do you wish to talk to us now? Pag sinabing yes, yan, so magsasalita. And of course, he should affix his signature in his affidavit, no, or sworn statement. And of course, para malaman din, no, na andun nga yung abogado, kailangan yung abogado ay mag-sign din doon po sa affidavit. Okay? Yan po, mga kapangarap. Okay, next. What is the proper procedure in making arrest and conducting custodial interrogation under the Philippine jurisprudence? Okay? So, Philippine jurisprudence dictates that correct procedure to be followed by police officer in making the arrest and conducting custodial interrogation. It is stated under People v. Gait in the Supreme Court report annotated 465, ladies and gentlemen. Ano daw ang susundin? At the time of a person, or at the time a person is arrested, it shall be the duty of arresting officer to identify himself. Yan, so magpakilala ka bilang isang pulis. Number 2, inform for the reason for the arrest and show the warrant of arrest if any to the suspect. Yan, so ipakita mo or sabihin mo yung dahilan kung bakit mo siya aarestuhin at ipakita mo yung warrant of arrest kung meron ka. Okay? Yan. And inform the suspect's rights or yung kanyang Miranda rights to remain in silent, right to have a counsel, and right to be informed of his right, ladies and gentlemen. However, there are exemption to the rule, syempre. Okay? So, pwede bang hindi na sabihin yung pong rights ng aarestuhin? Siyempre. Number 1, kung yung aarestuhin ay isang kilalang pusakal na kriminal. Okay? Number 2, kung yung pag-inform nung kanyang karapatan ay pwede pong malagay sa panganib ang buhay ng pulis. At number 3, kung yung pag-i-inform doon sa offender or doon sa tao ay pwedeng dahilan para siya po ay makatakas. So, yun yung mga pagkakataon na kung saan hindi mo muna kailangang sabihin yung karapatan ng isang taong inaaresto. So, pwede mo nang sabihin yon pagka pinupusasan. Diba? Ayan. What are the fundamental laws related to the rights of the accused? Okay, so these are some of the fundamental laws related to the rights of the accused, ladies and gentlemen. This is the statutory right. When you say statutory right, it is a right provided by the statute. We have Republic Act number 7438. What is RA number 7438? It is an act defining some certain rights or acts of rights of a person arrested, detained, and or under custodial investigation, no? As of course it also enumerates the duties of the arresting, detaining, and investigating officers and providing penalties for violation thereof. Ayan, so nakasaad din po sa ating RA number 7438 yung karapatan po ng isang inaaresto, ng isang akusado. Ayan. Okay, question. The law, which is otherwise known as the Anti-Torture Act, okay, is another law or which states the rights of a person arrested, detained, and under custodial investigation, na sinasabi dito na meron pong criminal liability yung isang tao kapag ka po tinorture mo, no? Yung pong suspect. So, anong batas yun? Letter A, Republic Act number 7438. B, Republic Act number 9745. Letter C, RA 6981. Or letter D, Republic Act number 10175. And the law which is otherwise known as the Anti-Torture Act is Republic Act number 9745, ladies and gentlemen. Republic Act number 7438 is the law which enumerates the rights of person arrested, detained, or under custodial investigation It also enumerates the duties of public officers. It was approved on April 27, 1992. Republic Act number 9745 is the Anti-Torture Act of 2009, and Republic Act number 6981 is the Witness Protection, Security, and Benefit Act, which was approved on April 24 of 1991. If there are witnesses who are afraid to talk, no? So pagka may mga natatakot na witnesses doon sa suspect, yan pwede mo pong ibigay sa kanila yung pong Witness Protection and Security Benefit Act, ladies and gentlemen. Maraming salamat sa inyong walang kawang pakikinig dito sa ating short video presentation. So patuloy lang pong mag-tune in para sa part 2 ng subject